any circuit has sided with your
You're right.
position.
Yeah, that's correct. But
the Honorable Judges for the United States Court of Appeals stand before the 7th Judicial Circuit. Period. All persons having business before this honorable court are admonished to draw near and give their attention, as the court is now sitting. God save the United States and this honorable court.
good morning, everyone. Welcome. Our first case for argument this morning is United States against Kelly. Ms. Bungie.
Thank you and good morning, Your Honors. May it please the court, my name is Jennifer Bonjean and I represent Robert Kelly. I am going to work backwards this morning and start by addressing the sentencing issue, but happy to field questions about any of the issues before the court. Mr. Kelly was indicted in a 13-count indictment. He was convicted of 6 counts. He was acquitted of 7 of those counts, including obstruction of justice based on a 2008 state court prosecution, conspiracy to receive child pornography, and then the receipt counts. Mr. Kelly was sentenced to a 240-month sentence, which was the statutory maximum, and a sentence significantly above the guideline range. And the district court judge properly calculated the guidelines, but then gave just essentially a polite nod to them and decided, I think 20 years is the right sentence. And the district court's justification for the above guidelines range lacked sufficient factual basis. That is our position. Generally speaking, he relied on acquitted conduct, and he relied on the guidelines today would punish this more severely. Therefore, we should give him an above guidelines range. Now, I want to first start with the acquitted conduct. If you look at the district court's comments, he both imprecisely and inaccurately stated that the evidence presented at Kelly's trial essentially showed that he engaged in some type of obstructive behavior.
Ms. Bungie, do we know, though, that the district court actually relied on that? Because the district court said, I could find by a preponderance that he obstructed justice.
And
There was no specific finding that he did.
Yes, and that's an excellent point, Your Honor. Our position is the judge was imprecise. He vaguely referenced, I could do this. It could be based on
But
this.
you want us to infer from that he actually did.
Well,
and what's the basis to do that given the judge's specific comments?
Well, I think what I would like the court to do is first find that his comments were too vague and ambiguous for us to find that what he relied on. And I think in our briefs, we said it was both procedurally improper. And then we argued that even if you accept the government's position that there was this basis, the judge did make this finding. And the comments were sort of a little bit of a stream of consciousness, if you will. And he said, I could do it. So our position, as our briefs, I think, set forth, is that it wasn't precise enough. He didn't identify the factual basis. But even if we looked at those factors, they would not provide a basis for an above guidelines range.
I don't think any circuit has sided with your position.
You're right. Yeah, that's correct. But
the district court sentencing seemed very grounded in the 3553 factors, and his concern for the seriousness of this offense and your client's history and characteristics, which is exactly what the courts must do, is look at the 3553 factors. How do you get around that?
Well, I think you still have to look at the guidelines range as a starting point. And I would remind the court that probation found that there was no basis to sentence him above the guidelines. And
But that's not determinative. The court has to look at 3553, which again, the court spent quite a bit of time on those factors, in particular, the seriousness of the offense, the need for deterrence here, protecting the public.
And those were all appropriate factors to look at. But when a court decides to go 72 months above a guidelines range, it still should identify factually specific aggravating factors that would justify it. Not simply say there was this acquitted conduct that I could find. And, again, our position is the government did not prove the acquitted conduct by a preponderance of the evidence. We know that because the jury acquitted him of the conspiracy to receive child pornography. So this wild goose chase that the judge referenced as sort of a basis for this above guidelines range is not borne out at all. In fact, the jury affirmatively rejected the government's narrative.
Different burden of proof.
I understand, but it's not even it's not logical. We sometimes see cases where maybe the government just didn't meet its burden, right? We can't assume that the jury would have not found it by the lower standard. But in this case, we can tell very clearly that they did not find that those tapes that were the subject of the wild goose chase were child pornography. If they had, they would have at least convicted Mr. Kelly of the conspiracy count. It's the same child pornography. They looked at the images on related to counts 2 and 3. They found it to be child pornography. And then they acquitted him of the conspiracy.
Ms. Bonjean, if we agree with you and send this back for resentencing, does your client realize he could end up worse off? Because the court did go above the guidelines, but very significantly, only 1 year is consecutive to the sentence that your client received in New York. So theoretically, if it's remanded for resentencing because of an error and the court gives a guideline sentence, which is what you seem to be arguing the court should have given, that entire guideline sentence could be consecutive or half of it or more than a year, which would put your client in a worse position. So does your client realize that?
Yes, Judge. I do think that if the net result was a more significant sentence, it would be retaliatory for exercising his right to appeal. So I don't think the judge could, and I frankly don't think the judge would
certainly could. If it's sent back for resentencing, the judge could start over and look at everything. So to say it would be retaliatory, there's no grounds for that or no case law that would support giving a higher sentence or a sentence that would have a more significant consequence.
Well, I think the second point is a more I think a valid point to some degree, but I do think there's plenty of case law that says you can't punish someone for exercising their right to an appeal, right? So if the judge were to give a net greater sentence, our position would be that was retributive.
I just want to make sure your client understands that if he wins on this particular point, he has risks. That he might get a higher consecutive sentence.
Yes, Judge, and frankly, to be frank, kind of all depends on what happens in the Eastern District, because
that's on appeal.
That's his life sentence right there, essentially. It's a 30-year sentence. So not to say this doesn't matter, but if that sentence sticks, he probably will die in prison. And that is the reality. So we have had these conversations if the court, is asking that, and we.
I don't think any circuit has sided with your position.
You're right. Yeah, that's correct. But and obviously we would acknowledge that some of these circuits have already sided with the government's position on this. The issue's in front of the Second Circuit presently. So
I don't think any circuit has sided with your position.
You're right. Yeah, that's correct. But perhaps there will be a split, and at some point. But our position is that the U.S. Supreme Court would see this differently in light of those general principles, and that we need to start there. And I think the court is well equipped with the information that we've provided and the government's provided to make that decision. I want to get back to this obstructive conduct very quickly.
I don't think any circuit has sided with your position.
You're right. Yeah, that's correct. But